Well, hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, I want to talk about the EEOC charge, the complaint that the plaintiff files with the EEOC office alleging discrimination, employment discrimination. Now, it is critical that this form is completed correctly, plaintiff. Otherwise, you could lose your right to sue on a particular claim or claims. And also, I want to talk about the GINA Act, and that stands for Genetic Information Non-Discrimination Act of 2008. You'd be surprised what employers ask their employees regarding their medical situation and the medical situation of their families. Well, you want to hear this. So let's get started. So let's look at the notice of charge of discrimination form. The complainant will complete this and submit it to the EEOC. Now let's look at the boxes that are available to make your employment discrimination charge. You want to check each box that is applicable to you. If each box is applicable, then you would check each box. Let's go to the next set of boxes. You want to check each box that is applicable to your situation. Here, the circumstances of alleged discrimination. It is really critical that you check the boxes that are applicable to you. Race, color, sex, religion, national origin, age, disability, retaliation, genetic information. Now, if you have a claim that is not listed for you to check a box, then you want to check other and include the name of that claim. That's critical, okay? Because otherwise, you could lose your right to sue for that claim, and we'll see that later in a case. Next, you want to date and sign the document. Now, this form will accompany the form we just went over. And if I'm not mistaken, I believe it goes on top of that form. So you have your information here, self-explanatory, but here's where it's important, the particulars. When you write your particulars for each claim, what you want to do is write them with the prima facie elements in mind. In other words, as you write your claim, you're going to stay within the purview of the facts, the law, which includes the prima facie elements. Okay, so stay focused. Don't just ramble, but if you stay within the parameters of the facts and the law and the prima facie elements, you will be focused because you want EEOC to be focused. Okay? Now, remember I said failure to check the correct box could result in the claim not being heard. In Coleman versus Kettler Management, that's what happened. The plaintiff failed to check the boxes for hostile work environment claims, harassment, and hostile work environment. Now, remember, let's go back to the charge form we just looked at. There were no boxes for harassment or hostile work environment. So in that case, she would have checked other and then mentioned those claimed. And the court found that because she failed to check those boxes or mention them, she waived her right to file a charge regarding those claims. In a nutshell, the court says she failed to put the defendant on notice of her hostile work environment theories. Very important. So let's look at the Genetic Information Non-Discrimination Act of 2008. Title 1 of GINA prohibits discrimination based on genetic information and health coverage. Title II of GINA prohibits discrimination based on genetic information in employment. So let's look at the case law. In EEOC versus Divulge Corp. LLC, doing business as Dollar General, EEOC filed a lawsuit against an Alabama Dollar General store. It alleged the store engaged in a hiring process that violated the Americans with Disabilities Act and the Genetic Information Discrimination Act. So let's look at some of EEOC's allegations that it grounded its lawsuit on. EEOC found that applicants for employment were required to pass a pre-employment medical exam and to divulge past and present medical conditions of family members such as cancer, diabetes, and heart disease. Plaintiff, pro se, should you ever be asked these type of questions, a red flag should raise. In addition, EEOC alleged that Dollar General used qualification criteria that screened out qualified individuals with disabilities. For example, Dollar General rescinded job offers to applicants whose blood pressure exceeded 160/100 or who had less than 20/50 vision in one eye, even when those impairments did not prevent the applicants from safely performing the job. And here is EEOC's statement on the law. Requiring individuals during the hiring process to answer invasive questions about medical conditions of their grandparents, parents, or children violates GINA, said EEOC Birmingham District Director Bradley Anderson. Anderson continues, an employer is prohibited from soliciting this information, regardless of whether the information is used to deny employment. Marsha Rucker, the regional attorney for the EEOC's Birmingham district, said this: the ADA protects job applicants from being denied employment because of a disability as long as they can perform the job with or without an accommodation. Employers cannot deny employment solely based on stereotypes about the abilities of individuals with certain impairments. Plaintiff, pro se, you got that? If it sounds and walk like a duck, it's probably a duck. In other words, be vigilant and be proactive. I am always glad to bring you information to assist you in your litigation. And I know, hearing from many of you, that you're being helped. And I'm thankful for that. I'm Advocate Lucinda, and we will see you next time. Take care.